Hello, this is Dr. Vikas Agrawal from Dr. H.S. Gore Central University, Sagar. The today's topic for the discussion is the arrest process in criminal justice administration. The process of arrest confers on the authorities a power to interfere with a person's freedom from physical restraint. From the point of view of the administration, the arrest is a process that ensures effective conduct of the investigation, prevention of the further criminal design, and availability of the accused for the purpose of trial and consequent punishment. Thus, the law of arrest entails fine balancing between the liberties of the arrestee on the one hand and the interest of the community to secure a crime-free society on the other. Often, the lawmakers, the administrators and the judges face a dilemma to secure a crime-free society, but at the same time, the rights of personal liberty of a person should not be infringed without any reasonable cause, and unnecessary arrest should be avoided. Learning outcome: by reading this module, the students will be able to analyze the concept and meaning of arrest, the police officer's power to make arrest without warrant, arbitrary arrest and the judicial response to it, the amendments made by the Criminal Procedure Amendment Act 2008 in this regard, the private person's power to make arrest, the magistrate's power to make arrest, and the mode of effecting the arrest. Now, the next question for the discussion is, what constitutes arrest? Black's Law Dictionary defines arrest as the restraint of a person's liberty through some lawful authority. The term arrest is not defined in the Code of Criminal Procedure. We can say that arrest can be defined as taking a person into lawful custody. Section 46 of the code only provides how the arrest can be made. It provides that the arrest can be effected by actual touching or confining the body of the person to be arrested. However, no such confinement shall be required when the person to be arrested submits himself or herself to the custody, as it was held by the Supreme Court in the case of State of UP versus Devman Upadhyay. However, if the arrest is resisted, then Section 46 subsection 2 authorizes the use of all the necessary means for the purpose of effecting the arrest, and the person to be arrested can be convicted under Section 224 or Section 225 for such resistance. For the purpose of effecting the arrest, only the reasonable force should be used. The force should be in proportion to the resistance only. Excessive force should not be used. Handcuffs are not to be used in all cases of arrest, as it was held by the Supreme Court in the case of Birendra Kumar Rai versus Union of India and Prem Shankar Shukla versus Delhi administration. Section 46 subsection 3 authorizes the causing of death for the purpose of effecting the arrest in certain circumstances. Section 46 subsection 3 provides that if the person to be arrested is alleged to have been committed an offence which is punishable with the imprisonment of death penalty or with life imprisonment, and he tries to evade the arrest, then for the purpose of effecting his arrest, his death can also be caused. Now, the next point for the discussion is legal framework of arrest. This can be divided in two parts, that is arrest under warrant. Chapter 6 of the Code of Criminal Procedure, that is from section 70 to section 81, provides for the arrest under warrant, and the another one is arrest without warrant. This can further be divided in two parts. One is general powers of arrest. In this regard, section 60A and from sections 41 to section 45 are relevant, and another one is special power or the preventive power of arrest. In this regard, section 151 of the Code of Criminal Procedure is relevant. Now, we will discuss arrest without warrant, as section 60A provides that no arrest can be made except in accordance with the provisions of this code or of any other law. We will discuss the provisions of this code in the following four heads. First is police officer's power to make arrest without warrant, arrest without warrant in case of non-cognizable offence, private person's power to make arrest without warrant, and magistrate's power to make arrest. Now, first one we will discuss the police officer's power to make arrest without warrant. Section 41 of the code gives power to the police officer to make arrest without warrant. Section 41 subsection 1 provides that any police officer may, without an order from a magistrate or without a warrant, arrest any person in the following circumstances. Here the term may suggests that this is a discretionary power of the police officer and it should be used only in the reasonable circumstances. Police officer is not bound to make the arrest in the circumstances which are covered by section 41. If there is any malicious exercise of the power by the police officer, then he can be convicted under section 220 of the Indian Penal Code. Now, we will discuss the various clauses of section 41 under which the police officer can make the arrest without warrant. The first clause is with regard to the arrest in case of cognizable offences. This part we will divide in two parts. One is position before the Amendment Act of 2008 and another one is changes made by the Criminal Procedure Amendment Act 2008. The original clause A of subsection 1 of section 41 provides that the police officer may arrest any person who has been concerned in any cognizable offence or against whom a reasonable complaint has been received or a credible information has been received or a reasonable suspicion exists of his having been so concerned. This section gives a very wide discretionary power to the police officer to make the arrest in case of cognizable offences, but this power should be exercised only in the reasonable circumstances and the unnecessary arrest should be avoided. As it was held in the case of Jogendra Kumar versus State of UP by the Supreme Court that no arrest can be made because it is lawful for the police officer to do so. Existence of the power is one thing and the exercise of it is quite another. No arrest should be made without a reasonable satisfaction reached after some investigation about the genuineness and bona fides of a complaint and a reasonable belief both as to a person's complicity and even so as to the need to effect the arrest. Denying a person his personal liberty is a serious matter. In this case, Supreme Court laid down some guidelines which are to be followed while exercising the power to arrest without warrant by the police officer. One is, an arrested person being held in custody is entitled to have any friend, relative or other person who has an interest in his welfare informed that he has been arrested and where he is being detained. Another one is, the police officer shall inform the arrested person of this right. And the third one is, an entry shall be required to be made in the diary as to who was informed of the arrest. Again, in the case of D.K. Vasu versus State of West Bengal in the year 1997, Supreme Court issued several guidelines for the purpose of prevention of arbitrary arrest. Some of the important guidelines are as follows. The police officer making the arrest should bear an accurate, visible and clear identification and name tags. Next one, that the police officer making the arrest shall prepare a memorandum of arrest at the time of arrest and such memo shall be attested at least by one witness and it shall also be signed by the arrestee and shall contain the time and date of arrest. Next one, the arrestee shall be entitled to have one friend or relative or other person informed that he has been arrested and is being detained at a particular place. Next one, the person arrested must be made aware of this right to have someone informed of this arrest. Next one, an entry must be made in the diary. Next one, the arrestee should also be examined at the time of his arrest about his major and minor injuries. Next one, the arrestee should be subjected to medical examination by a trained medical doctor in every 48 hours during his detention in the custody. Next one, the copies of all the documents including the memo of arrest should be sent to the magistrate for his record. Next one, the arrestee must be permitted to meet his lawyer during interrogation. Next, a police control room should be established at all the district level and at the state headquarter level. Now we will discuss the changes made by the Criminal Procedure Amendment Act 2008 for the prevention of arbitrary arrest. By this Amendment Act, Clause A and Clause B of Section 41 have been substituted with the following clauses. Now the amended Clause A provides that the police officer may arrest any person who commits in presence of the police officer a cognizable offence. Clause B provides with regard to the less serious offences. It provides that the police officer may arrest any person against whom a reasonable complaint has been made or a credible information has been received or a reasonable suspicion exists that he has committed an offence which is punishable with the imprisonment of less than 7 years. Then the police officer can arrest the accused in the following circumstances. That is, if the arrest is necessary to prevent such person from committing any further offence. Another one, for the purpose of conduction of the investigation. Next is to prevent such person from causing the evidence of the offence to disappear or tampering with such evidence in any manner. Next one, to prevent such person from making any inducement, threat or promise to any person acquainted with the facts of the case. Next one, as unless such person is arrested, his presence in the court whenever required cannot be secured and the police officer shall also record the reasons for making the arrest. Clause BA with regard to the serious offences, Clause BA provides that the police officer can make the arrest of any person against whom a credible information has been received that he has committed a cognizable offence punishable with the imprisonment for a term which may extend to more than 7 years or with a death sentence, and the police officer has the reason to believe on the basis of that information that such person has committed the said offence. Means now the amended clauses provides that the police officer cannot make the arrest in case of all the cognizable offence. Clause A provides that the police officer can make the arrest if the offence is committed in presence of the police officer. And with regard to the other cognizable offences which are not committed in presence of the police officer, clause B and clause BA are applicable. Clause B provides with regard to the less serious offences, that is the offences which are punishable with the imprisonment of less than 7 years. In case of those offences, the police officer can exercise the power of arrest only in those circumstances which are mentioned in clause B. And clause BA provides with regard to the serious offence, that is the offence which are punishable with the imprisonment more than 7 years or with the death penalty. In case of those offences, the police officer can make the arrest, but he must have reason to believe that the offence has been committed. Now we will discuss sections 41A to section 41D, which were also inserted by the Criminal Procedure Amendment Act for the purpose of prevention of arbitrary arrest. Section 41A provides for the issuance of notice before the arrest. This section provides that even in case of cognizable offences, police officers should not exercise the power to make the arrest without warrant. First of all, a notice should be issued to the person concerned for his appearance before the police officer, and in case the notice is not obeyed, then only the police officer should exercise the power to make the arrest without warrant. Clause 41B provides that the police officer, while making the arrest, must bear an accurate, visible and clear identification, and a memorandum of arrest shall also be prepared at the time of arrest. Section 41C provides for the establishment of control rooms at the district level and at the state level. Section 41D provides for the right of the arrestee to meet his advocate at the stage of interrogation. In this regard, the case of Nandini Satpathy versus P.L. Dani is relevant here. In this case, the Supreme Court has favoured the presence of lawyer during interrogation of the accused as a fundamental right under Article 20 Clause 3 and Article 22 Clause 1. In this regard, the recent case of Senior Intelligence Officer versus Jogal Kishore Samra decided by the Supreme Court in the year 2011 is also relevant here. In this case, the question before the Supreme Court was that whether a person called for interrogation is entitled to the presence of his lawyer when he is questioned during the interrogation under the provisions of Customs Act or the Foreign Exchange Regulation Act or the like acts. The Supreme Court gave the answer to this question in negative. Now we will discuss the other clauses of section 41 under which the police officer can make the arrest without warrant. Clause C of section 41 subsection 1 provides for the arrest of the proclaimed offender. This clause provides that any person who has been proclaimed as an offender under this code or by the order of the state government can be arrested by the police officer without warrant. Next one, clause D provides for the arrest of a person in possession of stolen property. This clause provides that a person who is reasonably suspected to be in possession of the stolen property or who is reasonably suspected to have committed an offence in relation to such property can be arrested by the police officer without warrant. Clause E provides for the arrest of obstructor or absconder. This clause provides that if any person obstructs the police officer while performing his legal duties, then he can be arrested without warrant. It is notable here that obstructing a public servant is punishable under section 186 of the IPC, which is a non-cognizable offence. But if any person obstructs the police officer while performing his duties, then he can be arrested by the police officer without warrant. Another one is escape from the lawful custody. Any person who escapes from the lawful custody, he can be arrested without warrant, and after that he can be convicted under section 224 of the IPC for such escape. Next one, clause F, is with regard to the arrest of a deserter. It provides that a person who is reasonably suspected of being a deserter from any of the armed forces of the Union can be arrested without warrant. Clause G provides for the arrest of the person having committed the offence outside India. Any person who commits the offence outside India can be arrested within the territory of India without warrant. It is also important to note here that it is not necessary that the act done must be punishable as an offence in that foreign territory. For the purposes of this section, it is also not important that a cognizable offence must have been committed. This clause is applicable in case of cognizable offence as well as non-cognizable offence. The next clause H provides for the arrest of a person who violates the conditions imposed under section 356 of the Code of Criminal Procedure. Next clause I provides for the arrest in case of requisition by another police officer. This requisition can be made either in oral or in writing. This is a clause to facilitate the arrest at a distance. Now the next point for the discussion is arrest without warrant in case of non-cognizable offence. As section 41 subsection 2 provides that no arrest can be made by the police officer in case of non-cognizable offence without warrant. But section 42 is an exception to that provision. Section 42 provides that if a non-cognizable offence is committed by any person in presence of the police officer, then for the purpose of ascertaining the name and residence of that person, the police officer can make the arrest without warrant even in case of non-cognizable offence. As soon as the name and residence is ascertained, that person shall be released from the custody. But if the name and residence cannot be ascertained within the period of 24 hours, then he shall be produced before the magistrate. Now the next one is arrest by the private person. Section 43 authorizes even a private person to make the arrest without warrant. A private person can make the arrest of the following persons: a person who in presence of the private person commits a non-bailable and cognizable offence can be arrested by the private person without warrant, and a person who has been declared as a proclaimed offender can be arrested without warrant by the private person. At one point of time, this was the question before the court, that whether a private person can seek the assistance of a third person for the purpose of making the arrest who has not seen the commission of the offence, because section 59 subsection 1 of the old code provided that any private person may arrest any person who in his view commits a non-bailable and cognizable offence or any proclaimed offender. Means according to this provision, a private person cannot seek the assistance of a third person for the purpose of effecting the arrest, as it was held by the Allahabad High Court in the case of Abdul Habib versus State, that a third person who has not seen the commission of the offence is not entitled to arrest. But now the new code section 43 provides that any person may arrest or cause to be arrested any person. Means according to the new provision, the assistance of a third person can be taken though he has not seen the commission of the offence. In the case of Inri Kolavennu, it was held by the Andhra Pradesh High Court that no arrest can be made under section 43 long after the commission of the offence. The expression actually used by the legislature under section 43 is commits and not had committed. If a private person makes a wrongful arrest, then against the private person the accused can exercise the right of private defence. He has the right to resist the arrest, and for such resistance he will not be convicted under section 224 or section 225 of the Indian Penal Code. But the private person can be made liable under section 340 for such wrongful restraint. However, the private person will not be convicted under section 340 if the arrest is bona fide. Section 43 subsection 2 provides that when such private person hands over the arrestee to the police officer and it is found by the police officer that such arrestee comes under section 41, then the police officer shall re-arrest him. Section 43 subsection 3 provides that when it is found by the police officer that such arrestee has committed a non-cognizable offence, then the procedure given in section 42 shall be adopted. Now the next one, arrest by the magistrate. Section 44 of the Code of Criminal Procedure authorizes the magistrate to make the arrest in the following two situations. One is any person who commits an offence in presence of the magistrate. Here it is important to note that this power can be exercised by any magistrate, whether judicial or executive, and in case of both the offences, whether cognizable or non-cognizable. Second one, any person for whose arrest such magistrate is competent to issue a warrant can be arrested by the magistrate. Now the next one, arrest of a female person. Now the next point for the discussion is how a female person and by whom a female person should be arrested. In this regard, the case of State of Maharashtra versus Christian Community Welfare Council of India decided by the Supreme Court in the year 2004 is relevant. After the various guidelines issued by the Supreme Court in this case, subsection 4 was inserted in section 46 by the Criminal Procedure Amendment Act 2005. It provides that save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where those exceptional circumstances exist, the arrest shall be made by a woman police officer after taking the prior permission of the Judicial Magistrate First Class. In the year 2008, by the Criminal Procedure Amendment Act, a proviso was inserted after section 46 subsection 1. The proviso provides that as far as practicable, a woman shall be arrested by a female police officer only. Now we will discuss some of the rights of the arrestee provided under the code in case of arrest without warrant. Section 51 subsection 1 provides the right to know the grounds of arrest. It is the duty of the police officer that police officer shall inform the grounds of arrest at the time of making the arrest. In this regard, the case of Vikram versus State is relevant here. In this case, it was held that an accused must be informed of the bare necessary facts leading to his arrest. It is difficult to prescribe any form in which the information must be given. An arrested person must know the grounds and the reasons and the facts that in respect of whom and by whom the offence is said to have been committed, as well as the date, time and place of the offence, etc. Section 50 subsection 2 provides that when a police officer makes an arrest without warrant in case of a bailable offence, then he is required to inform the arrestee that he has a right to be released on bail. In this regard, section 57 is also important here. Section 57 provides the right of the arrestee to be produced before a magistrate within 24 hours. The arrestee is required to be produced within 24 hours from the time of his arrest before the nearest magistrate. Here it is important to note that he can be produced before any nearest magistrate, whether he is having the jurisdiction or not. In this regard, the case of P. Swarupa versus State of Andhra Pradesh is also important here. In this case, it was held that this section does not authorize the police officer to detain the arrestee for the period of 24 hours in all the cases without any reasonable cause, because this section provides to produce the arrestee without any necessary delay. Now, the next point for the discussion is the law of arrest and the judicial process. As we have seen that the Supreme Court time to time has issued several guidelines for the prevention of arbitrary arrest. Recently, in the case of Arnesh Kumar versus State of Bihar, decided by the Supreme Court in the year July 2014, several guidelines have been issued by the Supreme Court for the prevention of arbitrary arrest. Supreme Court observed that no arrest should be made only because the offence is non-bailable and cognizable, and therefore lawful for the police officer to do so. The existence of the power is one thing and the justification for the exercise of it is quite another. The police officers must be able to justify the reasons thereof. No arrest can be made in a routine manner on a mere allegation of the commission of an offence. No arrest should be made without a reasonable satisfaction reached after some investigation as to the genuineness of the allegation. It was said by the Supreme Court that before exercising the power to make arrest without warrant, police officer must put himself some questions. That is, why arrest? Is it really required? What purpose it will serve and what object it will achieve? Only after addressing to these questions, the police officer should exercise the power to make arrest without warrant. In this case, Supreme Court laid down several guidelines. The first one, all the state governments to instruct its police officers not to automatically arrest when a case under section 498A of the IPC is registered, but to satisfy themselves about the necessity of arrest. Next one, all the police officers shall be provided with a checklist of the specifieds given in subclause B of section 41 subsection 1. The police officer shall forward the checklist and furnish the reasons and the materials which necessitated the arrest while producing the accused before the magistrate for the further detention. Next one, the magistrate, while authorizing the detention of the accused, shall pursue the report furnished by the police officer, and only after recording its satisfaction the magistrate will authorize the detention. Next one, the decision not to arrest an accused be forwarded to the magistrate within 2 weeks from the date of institution of the case. Next one, notice of appearance in terms of section 41A of the CRPC be served on the accused within 2 weeks from the date of institution of the case. It was also said by the Supreme Court that the directions aforementioned shall not only apply to the cases under section 498A of the IPC or section 4 of the Dowry Prohibition Act, but also to such cases where offence is punishable with the imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine. Now we come to the end of this module, and at the end we can summarize this module once again. That is, the arrest is required to be made for the purpose of effective conduction of the investigation, for securing the presence of the accused at the stage of trial, and for the purpose of prevention of the further criminal design. Arrest is required to be made. The Code of Criminal Procedure makes very wide range of provisions in this regard. Section 41 authorizes the police officer to make the arrest without warrant in the circumstances given in that section, but this power should be exercised by the police officer only in reasonable circumstances, and unnecessary arrest should be avoided. Time to time, the Supreme Court has issued various guidelines for the purpose of prevention of arbitrary arrest. Section 42 authorizes the police officer to make the arrest in case of non-cognizable offence. Section 43 authorizes even a private person to make the arrest. Section 44 authorizes the magistrate to make the arrest, and Section 46 provides how the arrest should be effected, and only the reasonable force should be used for the purpose of effecting the arrest, and the unnecessary force should be avoided. And at the last, Section 50 and Section 57 provides for the various rights of the arrestee in case of arrest without warrant. Thank you very much. Goodbye.